our presenters, John Morrissey and Leanne Kaczynski, both of whom practice in the general litigation group at Siskinds Law Firm. We pulled John and Leanne's bios from the website, and I would love to read them in their entirety, but then we wouldn't have time for the presentation. I assure you that John and Leanne are extremely accomplished professionals. Both have been named in the 2024 Best Lawyer, The Ones to Watch list, which recognizes outstanding professionals early in their career. So that's pretty wonderful. Thank you for joining us. We're really honored that you can do this presentation for us. John's practice focuses primarily on estate litigation, guardianship applications, and power of attorney disputes. And Leanne practices primarily in the areas of estate and capacity litigation, and she has significant experience in estate and capacity matters. And from what I can glean from the website, they both really like dogs. So John and Leanne, feel free to correct anything that I've gotten wrong during that introduction. And now I'm going to turn this presentation over to you. Thank you.
Yeah. Thanks, Catherine. Yeah, you kind of took my introduction. But John and I first wanted to say thank you to McCormick Home Dementia Services team for having us here to present on these really important topics, and we're very happy to be here. For today, John and I are presenting on the topics of incapacity, substitute decision-making, and the importance of planning ahead. And our goal for today is to provide you all with some background information regarding these topics so that if and when the time comes when you are asked to be power of attorney and you are required to make decisions, you'll have some background knowledge and understand your role and what you are required to do and how to do your role properly. So specifically today, John and I will be presenting on the following topics. So first, John is going to be discussing what is capacity, what are the different types of capacity, how do we know if a loved one no longer has capacity, and what happens if a family member does not have capacity anymore. Notably, John will be discussing whether a dementia diagnosis indicates that a family member has incapacity or not. I will then be discussing what is a power of attorney, what are the different kinds of powers of attorneys, how do we make one, when is a power of attorney in effect, and then also when is a power of attorney no longer in effect. John will then discuss what happens when we don't execute a power of attorney, and these are called guardianship applications, and he's going to discuss the process of how to commence an application and what's required when you are making that application to the court. Then I'll be discussing the duties and responsibilities of powers of attorneys and guardians, including what can I do and what shouldn't I do. And this is a really important topic for individuals that are going to be acting as a power of attorney for a loved one. So this is a really important topic, and we'll just go over those duties and responsibilities. And then John's going to go over the common issues in power of attorney matters that we often come across in our estate litigation practice. And we'll discuss how to avoid those common issues going forward. And then I will lastly be discussing like the red flags that John and I see when we're dealing with financial elder abuse. So if the unfortunate event arises where you see some activity that concerns you, you'll understand, is this a red flag? Is this something that should concern me? And then how do I address it? And then, as was mentioned, we're going to have time for a question and answer period. And we also have some sample questions as well that we get commonly asked about, and we can address those too if there's time.
All right, thanks, Leanne, and hello, everyone. So many of the files that Leanne and I work on touch in on the subject of capacity, a person's ability to do something. You know, does mom have the capacity to make a will? Does dad have the capacity to grant powers of attorney? And from a legal perspective, when we refer to the term capacity, we're usually referring to what is known as decisional capacity, a person's ability to understand information relevant to a particular decision and the corresponding appreciation for the reasonably foreseeable consequences of making a decision or not making a decision. And so by way of example, let's just consider the decision or the lack of a decision to make a will. If I'm assessing someone's capacity to make a will, I would want that person to be able to explain to me why they want to make a will. What's the motivation for making a will? What's the purpose of the will? What property do you own? How do you want to distribute your estate? Why do you want to distribute your estate in the manner you propose to distribute your estate in? What is achieved if a will is made, and what are the consequences if you do not make a will? So as you might imagine, in our estate litigation and capacity practices, Leanne and I are often faced with situations where there's an allegation that a person did not have the requisite legal capacity to do something, to make a will, to make a gift, to get married, to grant powers of attorney, to make decisions with respect to the management of finances or personal care. One of the difficult aspects in dealing with capacity is that quite often we're trying to determine if a person had capacity to do something 2, 3, 4 years after a decision was made. And so Leanne and I are often combing through historical medical records and collecting anecdotal evidence that will support the case we're trying to make that a person did or did not have capacity at the material time. And to make this even more complicated, capacity is task and time specific. And so I'll unpack that. So this means that a person may have capacity to grant a power of attorney in the morning, but not in the afternoon, or they may no longer have capacity to manage their finances, but they do have capacity to choose who they want to manage their finances. And when we speak about capacity, it's also important to consider the fact that capacity is not synonymous with making good decisions. Quite often, Leanne and I meet with people who are confident that their loved one did not have capacity because they made a decision that they didn't necessarily agree with. But many people who are capable, including myself, make poor decisions sometimes on a daily basis. It doesn't mean I'm not capable of making decisions or managing my affairs. So the concept of capacity seems simple, but in practice, addressing capacity can be quite complex. So capacity is decision specific. And what we mean by that is that over time, through legislation, but primarily through law that has been created by the courts, by judges, different levels of capacity have been established for different types of actions and decisions. For example, the level of capacity required to grant a power of attorney for property, choose who you want to make decisions for you with respect to your property when you become incapable, is different than the level of capacity to grant a power of attorney for personal care, which is a document that appoints someone to make decisions with respect to personal care matters. And the capacity to make a will is different than the capacity to become married. And the fact that there are different levels of capacity often comes as a shock to people who Leanne and I speak with, who often seem to espouse the position that if a person is incapable in one area, well, they must be incapable in all areas, which isn't always the case, and quite often is not the case. But if you carefully consider the consequences that may arise from a given decision, it becomes more clear as to why different levels of capacity have been established based on the decision that's being made. And so I always use this as an example when I'm speaking with my clients. Let's consider powers of attorney. As you may know, there's two types of powers of attorneys. There's power of attorney for property, a continuing power of attorney for property. And that's a document where you appoint someone who's going to make decisions for you if you become incapable about the management of your finances and your property. And then there's a power of attorney for personal care. And as I mentioned earlier, that's a document where you appoint someone who will make decisions for you if you become incapable in the various areas of personal care, such as hygiene, shelter, nutrition, clothing, safety, and so on. And so the degree of capacity required to grant a power of attorney for personal care is far less than the degree of capacity required to grant a power of attorney for personal care. And in my view, I think this makes a lot of sense because the level of harm that an attorney for property can inflict is far greater than the sort of harm an attorney for personal care can afflict. A person acting under a power of attorney for property, they can sell your house, they can empty your bank accounts, they can invest and reinvest your money, they can take out a mortgage, they can do anything that you can do while capable with your property. And because of this, when someone grants a power of attorney for property to an adult child or to a relative or to a friend, the legislature thought it prudent to elevate the level of capacity required to do so to be certain that the person who's granting the power of attorney knows exactly what they're doing. They know the risks and consequences of granting the power of attorney. So this is also a question that Leanne and I are also faced with. Does dementia indicate incapacity? And the answer is no, not always. Contrary to popular belief, a dementia diagnosis does not necessarily mean that an individual is incapable of managing their affairs or granting powers of attorney. As you are all well aware, people who have been diagnosed with dementia can remain very capable of managing their affairs long after the diagnosis. Each person's circumstances are different. Each person's diagnosis is different. And my position is that it's entirely unfair to conclude that because a person has been diagnosed with an illness that impacts their cognition, that person is automatically stripped of their autonomy and their right to make decisions. Now, with that being said, if a person wants to make a will or provide a gift or grants powers of attorney or continue to manage their affairs, but that same person has been diagnosed with an illness that might impact their cognitive functioning, there are certain steps that person can take before making a will, before granting powers of attorney, to determine whether they remain capable of doing so. So how do I know if a person lacks capacity? Well, that's a great question. And that's a question that Leanne and I face on a daily basis. Determining whether someone has capacity can be difficult, and raising the issue of whether a client has capacity is inherently uncomfortable as capacity for self-determination, governance. It goes to the root of a person's autonomy. If there are concerns that a person does not have capacity to manage property or personal care, as a first step, I always encourage a visit to the family doctors so that the person can undergo some preliminary cognitive testing, which sometimes is beyond the scope of a family doctor, in which case a referral might be made to a geriatric specialist or to a memory clinic where a professional can administer some cognitive testing. If an assessment does reveal that there may be cognitive impairment based on whatever assessments have been administered, my next suggestion is that the person in question proceed with something known as a capacity assessment. Capacity assessments are different than the sort of assessments that a doctor can perform. They can only be performed by people who have received special training with respect to assessing capacity and who have been recognized as designated capacity assessors under a piece of legislation that Leanne and I live in, known as the Substitute Decisions Act. Leanne and I work with capacity assessors on a daily basis. Now, unfortunately, these assessments can be costly, anywhere between $1,000 and $5,000, depending on the circumstances of the given case and what areas of capacity are being assessed. But these assessments provide a great deal of insight into whether a person does or does not have capacity to make certain decisions or to do certain things, such as make a will or grant powers of attorney. Now, if a person is assessed and is found to be capable of making new powers of attorney, that assessment provides the lawyer who's preparing the power of attorney documents with peace of mind. And it also provides the person who is assessed with peace of mind because they know that if the document that they're making, a will, a power of attorney, if it's ever challenged in the future, they can point back at this capacity assessment to say, well, hold on, I was assessed on September 1st of 2023. I made my power of attorney on September 3rd of 2023. I was capable on September 1st. Therefore, I was likely capable on September 3rd. And in Leanne's practice and my practice, quite often, if there's a will challenge or a challenge to the validity of a power of attorney document, those challenges are quickly disposed of if there is an accompanying capacity assessment report confirming capacity. Importantly, on the subject of capacity assessments, the person who's being assessed must consent. The only way that you can dispose of a person's consent is if a court orders that the person be assessed. And from my experience, courts are very reluctant to order a person to undergo a capacity assessment simply because these assessments can be intrusive and they do go to the soul or to the heart of a person's autonomy. And so courts will not order an assessment unless it is abundantly clear that there's evidence that a person may not have capacity.
Okay, so I will be discussing what is a power of attorney. So a power of attorney, as John stated, it is a legal document that appoints a person that the grantor chooses who will make decisions on your behalf in the event that you become incapable of making those decisions. As John went over, excuse me, there are different levels of capacity for certain decisions to be made, such as property, which, as John just said, requires a higher level, understandably so, versus personal care decisions, requiring a lower level of capacity. Therefore, there are two different types of powers of attorneys that can be executed. And again, they are power of attorney for property and a power of attorney for personal care. Under the power of attorney for property, the person that the grantor names will be able to make any decision that you can make except for making a will. And as a power of attorney for property, they can make decisions about investments. They can make decisions with respect to whether a property needs to be sold. Can also make decisions on management of a property if a property is not to be sold. They can pay the person's expenses and liabilities, determine income, as well as apply for applicable government assistance. Under a power of attorney for personal care, the person that's appointed by the grantor can make decisions such as shelter. So if a nursing home or long-term care is required, nutrition, if there's a particular diet that the individual needs to follow, that will be managed as well. Security concerns. So again, if there's physical limitations, whether long-term care is more appropriate or additional supports that are needed, the power of attorney for personal care will manage that. It should, however, there should be a distinction. It doesn't mean that the power of attorney actually has to provide the care. More so they're managing that personal care. However, there are some circumstances where the power of attorney for personal care will be the actual person that's the caregiver and providing that care, but it's not a necessary requirement. So the next thing that I'm going to discuss is how do you make a power of attorney? And there's different ways that a person can do that. Most commonly, a power of attorney document can be prepared and executed with the assistance of a lawyer that specializes in estate law. Power of attorney documents, however, can also be found online or from the public guardian and trustee. And the public guardian and trustee is a government organization in Ontario that oversees the management of property for incapable adults in Ontario. The problem, though, with doing a power of attorney document that's not with the assistance of a lawyer, it can come with some issues that John and I routinely come across. For example, the power of attorney document was not executed with the requisite formalities required, such as the document actually being signed by the grantor. And this may seem obvious, but we've come across cases where the power of attorney document was not actually executed by the grantor, which raises validity concerns. Other formalities include having two witnesses sign, view the execution of the document and viewing the grantor actually executing the document. And then also the witnesses further cannot be the spouse or children of the person that's being appointed. Also, when a lawyer is not involved in this process, it also raises potential concerns of whether the grantor had capacity to execute a power of attorney for property or personal care, and then also whether the grantor was under undue influence. And when we mean by undue influence, this is a legal term, and it's whether there was coercion placed on the grantor to make a particular decision, and making the particular decision of granting a certain person as the power of attorney for property and personal care. So usually when there's a lawyer that's assisting someone with the preparation and execution of a power of attorney for property and personal care, they're usually assessing whether there are any red flags of undue influence, but also making sure that the individual is capable of executing that document. So when there isn't a lawyer involved, it does raise issues sometimes, and John and I come across many cases where this can give rise to litigation. And this is particularly when family members are not on the same page and are aware of what's going on. So it is recommended to do these documents with the assistance of a lawyer who can properly assess capacity, whether there's undue influence, make appropriate notes. So in the future, you don't come across challenges. Further, when you are making your power of attorney document, the biggest consideration is who are you naming as your substitute decision maker. So usually when you're signing a power of attorney document, again, there's two documents: power of attorney for property, power of attorney for personal care. You could name the same person under both documents. So you can have the same person be the attorney for property and also be the attorney for personal care. That's not a requirement. You can have two different individuals for the two different types of roles. You can appoint more than one person as your attorney for property or your attorney for personal care. There's two different ways of appointing two or more people as your attorney. So first, they could act jointly, and this is specified in the actual power of attorney document. And what this means is both individuals will have to act jointly, make all decisions together. If, let's say, for example, that a bank account needs to be opened, both attorneys would have to sign in order to open that document. So it can be a good situation when the two individuals are on the same page. They both live somewhat close together. However, if you have two or more attorneys that aren't necessarily living in the same geographical location, it can't always be there to make decisions or sign documents. That can be difficult, but there's another way that you can appoint two or more attorneys, and that's jointly and severally. And what this means, and again, it's specified in the power of attorney document, but the two individuals, they can make decisions concerning whether it's property or personal care. They are required to consult with one another, but they don't have to sign everything, such as opening a bank account. And they also could make decisions without the other individual being there and consenting, and that can raise issues if the attorneys are not on the same page as well. So these are important considerations to make when you're considering who and if I should appoint more than one person. And just one last thing about who you should appoint. They don't have to be someone with the business or financial knowledge to act as your attorney for property, although those are great qualities to have in an attorney, but it's not a requirement. You can always seek the advice of investment advisors or a lawyer if you need any assistance with your role. And then again, with a power attorney for personal care, you don't need to appoint someone that you think is going to provide you with the best care. Well, you do want someone that's going to provide the best care for you, but they don't actually have to provide the care. They're more managing those care decisions. So you want someone that you trust in making those particular decisions for you. Okay, so when and how is a power of attorney enacted? And I think John would agree, it can be a difficult decision on determining specifically when a power of attorney was enacted. And we do have a difficult time proving specifically when a power of attorney was enacted, but these are general guidelines that we follow. So first we look to the power of attorney document. So for example, for a power of attorney for property, these types of documents can take effect immediately if they're termed as continuing powers of attorney for property. And these are the more common power of attorney for property documents that you see. So in these types of situations, this type of power of attorney is enacted when the grantor has become incapable of managing their property. And then the power of attorney then uses this document at an institution such as a bank or at a nursing home. And that's generally sufficient to enact the power of attorney document for property. However, there are some cases, and this is stated in the power of attorney document, where the grantor has specified that a doctor's letter or a capacity assessment evidencing that they're actually incapable is required to be obtained before the POA can be enacted. And then again, this will be specified in the actual document. And yeah, so the wording again will specify that in the document. So it's very important to be, when you're, especially if you're going to a lawyer to assist you in drafting those documents, to really have that conversation with the lawyer so you are sufficiently relaying your instructions, and whether you want your power of attorney to get a doctor's note or capacity assessment, or simply make the determination that they have concerns about your capacity, they believe you to be incapable, and then they're enacting the document with an institution. Okay, and then when is a power of attorney no longer in effect? So there's 3 circumstances in which a power of attorney document will no longer be in effect. So first, a more recent power of attorney has been executed by the grantor, which then immediately revokes the previous POA that has been executed. And again, this can be done in the POA for power of attorney for property context or power of attorney for personal care. The second circumstance is when the POA or the power of attorney has been terminated or declared invalid by the court. And this is usually following litigation proceedings that have been commenced by John and I, for example. If there was allegations of misappropriation of funds by the power of attorney, that is usually sufficient grounds to have the power of attorney removed. Or the court has declared that the grantor was incapable of executing that power of attorney document, or was under undue influence when they execute that POA. So that's another way that the power of attorney can be no longer in effect. And then 3, the grantor passes away. And this is an important distinction, and that John and I commonly get questions about this. And the POA document is active while the grantor is living. So upon the grantor passing away, the power of attorney document is no longer in effect. And then upon death, the last will and testament of the grantor then comes into effect. And then under the last will and testament, whoever has been named as the executor, they now have the authority to manage the estate assets and then administer the estate.
So what then happens if you do not grant a power of attorney? And certainly there are no laws or rules or regulations that require you to grant powers of attorney. It's perfectly within your prerogative not to grant powers of attorney. However, if you do not have valid powers of attorney in place and you subsequently become incapable of managing your affairs and making decisions, you will likely run into some serious issues that will require court intervention. And a good portion of the files that Leanne and I work on only exist because a power of attorney was not in place, a person becomes incapable, and Leanne and I are hired to repair the situation because the family members of the now incapable person, they're having a really difficult time accessing their loved one's bank account to pay bills, dealing with the CRA, dealing with utility companies. The list goes on. And it can be quite costly to run off to court to remedy this issue. Sometimes it's unavoidable, but more often than not, it's entirely avoidable if you simply plan ahead. So if you don't have a valid power of attorney document and you become incapable of managing your affairs, there's no person who has legal authority to make decisions for you. And some people try to get around this by adding a capable person on an account, a joint account, a son, a daughter, a relative, a friend. However, this doesn't resolve issues with filing taxes, dealing with the CRA, banks, government agencies, long-term care homes, anything relating to your property and finances. If you do not have a valid POA in place and you become incapable, you will inevitably hit a roadblock. Sometimes it's the roadblock is met a month, 2 months after incapacity. Sometimes people manage to get by for 2, 3, 4 years before they hit that roadblock. But almost always you hit that roadblock and you're told by the bank, by the CRA, by other financial institutions, long-term care homes, you need to go and obtain a guardianship order in order to make the decisions that you want to make on behalf of your loved one. So it's really important to plan ahead so that you have someone who you trust and who you rely named as your attorney in the event that you do become incapable. If you become incapable and don't have a power of attorney in place, someone is going to have to apply to court to be given that legal authority to manage your affairs. And once appointed, this person or persons are known as a guardian. And the obvious benefit of having a power of attorney in place is that you, the grantor, get to choose who your attorney is. On the other hand, with guardianships, you don't necessarily get to choose who your guardian is. In fact, your capacity could be so diminished by the time a guardianship application is brought, you don't even know that someone is applying to become your guardian. It's just something that you're not capable of comprehending. And you might find yourself with a guardian who you never in a million years would want to be managing your money or making healthcare decisions for you. Issues surrounding incapacity and the lack of a power of attorney, they're more common when we're talking about situations where a person does not have a power of attorney for property. With respect to power of attorney for personal care, if you don't have one of those, there is a piece of legislation called the Healthcare Consent Act that sets out a hierarchy of who gets to make decisions for you if you become incapable and you do not have a power of attorney for personal care. And this can be helpful in a pinch when a decision needs to be made on the fly at the hospital. What do you want? What do you want us to do with your mom or dad? Do you want us to do this or do this? The Healthcare Consent Act can be very helpful. However, it also can have its unintended effects, which is you could find yourself having someone on the hierarchy making a decision for you who you would never want to make a decision for you, an estranged child, an estranged relative, all of a sudden is making life or death choices for you. So, well, you can get by without having a power of attorney for personal care. It's always advisable to plan ahead and ensure that you do have a power of attorney for personal care and for property in place. So as a lawyer who deals with the consequences associated with a person not planning ahead, Leanne and I cannot emphasize enough how important it is to plan ahead by making sure that you get your power of attorney documents in order sooner than later. Incapacity can creep up slow on you, or it can happen in a flash, a car accident, some sort of other personal injury that affects your cognition. There are many young people who do not have powers of attorney in place, and they find themselves in a situation where they get injured, their cognition is affected, they can no longer make decisions on their own behalf, and someone's running off to court to be appointed there as their legal guardian. And so I'll talk briefly then about guardianship applications. Leanne and I really like guardianship applications. It's really interesting work. It's sometimes heartbreaking, though, the situations that we're dealing with, because more often than not, they are completely avoidable. Sometimes they're not. You can't avoid them. For example, consider the situation where a person is born with a very serious disability. That person may never have capacity. And so when that person turns the age of majority, when that person turns 18, quite often we'll have mom or dad applying to court to become the guardian of guardian of the person and guardian of property for their disabled adult child. But we also see guardianship applications when there is no power of attorney in place, or where there is a power of attorney in place, but the attorneys who are appointed in the document have themselves become incapable or they've died, or where the court might terminate a power of attorney document such that there's no person who has legal authority to make decisions on your behalf. So in terms of the process, what needs to happen is this: a person will apply to the Superior Court of Justice seeking guardianship over a person's property and or person. You need to satisfy the court that the alleged incapable person is in fact incapable. Usually a doctor's note will work, or a capacity assessment that I spoke of earlier. Those will work. You need to put certain people on notice of this application. Of course, the alleged incapable person has to be put on notice of this application, because we're talking about a pretty serious matter when decision making is taken away from the incapable person and put into the hands of someone else. You're also putting on notice the incapable person's spouse, their children, their siblings, their parents, and this gives an opportunity for all these interested parties to either confirm that the proposed guardian is a good choice, or that the proposed guardian has no business whatsoever making decisions for the incapable person, in which case sometimes we see competing guardianship applications, a brother and a sister fighting about who gets to make decisions for their incapable parent. And when that happens, we have a court actually having to decide which guardianship application, which proposed guardian should be the successful guardian who's tasked with making decisions on behalf of the incapable person. More than one person can be appointed as guardians. Quite often, if we're dealing with an adult child who has a disability, mom and dad will both apply. Similarly, if we're dealing with an incapable adult, you might have a brother and sister who get along. They might apply to become the joint guardians of property and or person. And if there's no one who's willing to assume that role, the Office of the Public Guardian and Trustee sometimes, in certain circumstances, will step in and assume that role as a statutory guardian of property. Rarely do we see the Public Guardian and Trustee's Office assuming the role as a substitute decision maker, as a guardian of person, simply because there's that hierarchy in the Healthcare Consent Act, and there's usually someone who is available to make at least to make decisions about healthcare related matters. Now, when you make this application to court to be appointed as a guardian, you have to demonstrate to the court that you are the right person or persons to assume that role. And in doing so, you have to set out your plans for how you intend to manage the person's property and personal care decisions. And that plan is submitted to the court, but it's also submitted to the public guardian and trustee's office, and they will vet that plan to make sure that all the I's are dotted and T's are crossed, and the plan makes sense. And if it doesn't make sense, or if they have issues with it, the PGT will make recommendations to the lawyers assisting with the application and to the court, setting out, what they think should be changed in the plans that would be in the best interests of the incapable person. And as we've mentioned a few times now, guardianships can even be pursued if there are valid powers of attorney in place. And we see that when either the power of attorney is misbehaving such that that power of attorney should be removed, or we see that where the power of attorney document, or the attorney named in the document themselves becomes incapable of making decisions for themselves, and so how are they going to make decisions on behalf of someone else?
So I'm going to now discuss what are the duties and responsibilities of a power of attorney and guardian. And again, we use power of attorney and guardian interchangeably because they have similar duties and responsibilities. So both attorneys of property and personal care and guardians of property and of the person for adults are governed by the Substitute Decisions Act. Again, as John said, we both live in this legislation. And it's a guide for attorneys and guardians on what they can and cannot do. It's also an important piece of legislation for you to review if you do have any questions. So under the Substitute Decisions Act, attorneys are required to consult the incapable person and supporting family members in the management of the person's affairs. Even if a person is incapable of making decisions pertaining to their property or personal care, it is important to consult the individual to the extent that you can to ascertain their wishes, because we want to maintain the person's agency and independence to the extent possible. So this is an important requirement of attorneys and guardians. It's also important to consult with supporting family members that may not be the attorney or guardian, but they may have appropriate suggestions to help you. And also it's important to keep them in the loop of what's going on in the person's, whether it's property or personal care affairs. So a power of attorney for property or a guardian of the property, they can do anything with respect to the management of property, except they cannot make a will. And this also includes beneficiary designations. So a power of attorney for property and a guardian of property cannot change beneficiary designations. So TFSAs, RSPs, anything that has a beneficiary designation, they cannot change that. And then again, they cannot change the contents of a person's will. And this makes sense because the grantor executed a will and executed these beneficiary designations when they were capable. And these were their wishes at the time. So you can see, like, there would be issues that would arise if the attorney or guardian was able to make changes to those documents. So it's an important legal principle that's there. I did touch on this briefly, but duties for a power of attorney property include applying for government benefits, making investment decisions, collecting debts, paying bills, maintaining the house if there is one. And then duties of personal care can include making decisions on shelter, including which nursing home to choose, and then making decisions on nutrition, safety, and so on. And I did cheat a little bit and I looked at the question and answer. And I did notice that there was a question pertaining to a power of attorney for personal care making decisions on shelter and the decision on whether that person should go into a nursing home. And we can discuss this later, but the question was whether there's a limitation on the power of attorney for personal care and their ability to place a person into a nursing home, because there are social service organizations that do their own capacity assessments on whether that person should go into the nursing home. And I would say that that's not necessarily a limitation on the power of attorney for personal care, but rather it's the capacity of that person to go into the long-term care home. So again, we're determining whether this person has the capacity to manage certain personal care decisions, such as shelter. And I would say that when the social services are doing their assessment, it's tied to that, the capacity to live independently, to make that decision on shelter. And if they're found incapable, then it's the power of attorney for personal care would be enacted to make that shelter decision, and where that long-term care placement would be, of course, depending on availability. If that answers your question, great. If not, we can get back to it at the end of the presentation. But it was a good question. So under the Substitute Decisions Act, there's this requirement, and it's an important requirement, that the power of attorney for property or guardian of property needs to keep proper accounts of all transactions that are coming into and out of the incapable person's accounts. We often suggest to make the structure of what you're managing as simple as possible. So we often recommend to have just one bank account, if possible, in trust for that person, and to use direct withdrawals of income where possible, and then withdrawals to come from that actual account, so automatic payment withdrawals, so you know exactly where the funds are going. We often advise to avoid cash withdrawals if you can, because it's hard to account where that cash goes. We also suggest avoiding transfers between various accounts, particularly if you don't keep track of whose account you're transferring the funds to. And also, like, the transfers don't provide a lot of description. We also recommend using file folders for bank statements, checks, as well as keeping receipts and keeping that file folder for the month or year, depending on the amount of documentation that you're accumulating. And this is the biggest issue we see, is just keeping the proper accounts. And John and I, one area of practice that we also do is passing of accounts applications, so estate accounting. And oftentimes we are representing an attorney and they've been asked to pass their accounts, and we have to be able to prepare the accounts and to show the court and whoever's objecting to these accounts, usually another family member, what's happened during when the funds are being managed. So we have to show what's coming into, we call it the estate, but even though the person's still living, and then what's coming out. So we always tell individuals to keep proper accounts, and it will avoid a big headache into the future. And also, if litigation is arising out of the accounting, it also keeps your legal fees lower. We also suggest avoiding the use of joint bank accounts and the commingling of funds. Again, very difficult to account for the incapable person's funds and sorting out whose funds are whose. Of course, you must never use the funds for your own personal use. All transactions using the incapable person's funds must be for their benefit. And then if you are making investment decisions, we often recommend that you seek the advice of a professional, particularly if you're dealing with larger sums of money. It's really important to have that individual there to assist the attorney or guardian. And then when, let's say there's been a guardian of property appointed through the guardianship application situation that John just discussed. We often have a management plan, which sets out what's happening with the plan, what's happening with the incapable person's funds. So if you're a guardian of property, you need to follow that management plan closely, because if you don't, then there could be issues that arise there, and with that, we would have to assist you and address those potential issues. And again, just if you are an attorney, just please keep proper transactions, notes, receipts, bank statements. Keep it simple. It'll just help you in the long run.
Okay, so common issues in power of attorney matters. So Leanne and I could spend hours, days even, talking about the sort of issues we encounter on a daily basis in our practice when it comes to power of attorney disputes. And the question that Leanne read out and answered is a classic example. But just to run through big picture, to run through a few of the type of issues that we see. Quite often we'll deal with allegations that the power of attorney document is not valid due to the fact that it was not properly executed. The person did not have capacity to do so. The person was subjected to undue influence such that the power of attorney document doesn't truly reflect what they want to be in the power of attorney document. Another one is misappropriation of money, missing money. The way that this matter usually presents itself is someone will call me and they'll say that their brother or sister is the power of attorney for their elderly parent, and that the brother or sister is living with the elderly parent. The brother or sister doesn't work, but somehow the brother or sister has a new Corvette or is taking these lavish trips all over the world, which just doesn't make sense because they don't have money. And so there's a suspicion that the sibling is in fact using their elderly parents' bank account as their own personal ATM. And we have countless examples of that exact scenario happening. We also deal with allegations that an attorney is making poor decisions. I'll have a client call me and say, my sibling put mom into a long-term care home, but mom doesn't want to go into a long-term care home. She wants to stay at home. She's capable of staying at home. She's only going to deteriorate if she goes into a long-term care home. We might have situations where there's an allegation that the attorney's not managing the money properly, making poor decisions, investing in companies that they have no business investing in. So poor decisions is a big one, and restriction on visitation, and this one walks into the office all the time, this issue, and there's no real easy answer to this. An attorney and a guardian have a duty to foster a relationship between an incapable person and supportive friends and family. However, what sometimes happens is if there is a rift in the family and certain siblings don't get along, you might have the attorney for personal care acting as a gatekeeper to their mother or their father, which causes a lot of heartache in the family because you can't go see your mother or father, and these are the latter years of their life. You want them to see their grandchildren, and you want to spend that quality time with them, but you can't do it because your brother, who's also the attorney, absolutely hates you. And so getting around that and dealing with that, it's very difficult, but it's quite common. And then finally, these competing guardianship claims, which we see quite often. These are expensive. They quite often tear the family apart. Once litigation starts with respect to power of attorney issues or guardianship issues, usually you've passed the point of repairing the family relations. So really unfortunate, very sad situations. But these issues, it's always possible, and quite often it's advisable to commence a court proceeding to have the court intervene and prevent unnecessary harm being inflicted on an incapable person. But these issues are often complicated, and they have a rich history dating back, 15, 20 years to a sibling feud. And going to court on these matters is sometimes the only way to really address an issue. But Leanne and I are always very clear with our clients that litigation is inherently unpredictable. It has the propensity to be extremely extensive. And so to that end, we're quite often recommending to our clients to engage in out of court dispute resolution processes, such as mediation.
Forgot to unmute myself. So although red flags, or there's not red flags of financial elder abuse in all cases that we come across. However, I think John would agree, it's becoming a bigger issue that we are seeing and that we are having to address. And through these cases, we've seen certain red flags pop up routinely that we thought would be helpful to address and to discuss with you, just in the unfortunate event, if you have concerns that there is financial elder abuse occurring in a situation and with someone that you know. If you see these flags, then maybe you should address those concerns and talk to a lawyer to discuss your options. So common red flags, and John just touched on this a little bit. So restriction in visitation access. We've seen this common coming up a bit more. And this is usually combined with these other red flags. And so restriction in visitation access, it could be like a power of attorney restricting access to other family members just suddenly from seeing a family member. And this could be under the guise of safety concerns, although there may not actually be safety concerns. So we have seen that. Not necessarily in the nursing home context. It can also happen if the family member's at home, but then there's a restriction in family members coming to visit and talking. We've seen manipulation. So this kind of ties in with the restriction of visitation access too. Manipulation regarding how this incapable person views other family members. So there may be a change in how this person views one of their children. They may be suddenly making comments about this child's taking funds when that may not have actually been the case. So manipulating views on other family members to, again, exert control and restrict visitation access. And then you see this happen quite often, powers of attorneys in last will and testament documents suddenly changing later on in life and excluding sometimes most family members that were under the previous will. And oftentimes it's usually one person suddenly benefiting for the entire estate and having sole control over property and personal care decisions, and then also being named as executor, and then also as the sole beneficiary of the estate. So that's usually a red flag. Also property transfers suddenly being completed, so usually benefiting one person. There's been an uptick in cases involving the addition of an adult child to property title and holding the property jointly with the adult parent. And again, with joint property ownership, the property will bypass the state and will go to the remaining person who's still living. So in that particular scenario, the adult child would hold sole title to the property. So we're seeing that often. And then funds suddenly being transferred out of the bank account, large withdrawals, investments being depleted, but the person's spending habits have not changed. For example, they may be in a nursing home where their expenses are generally pretty set by month. And then we have seen cases where the incapable person or where they have diminished capacity, they're not aware of the amount of their funds and they're being told incorrect information, such as they have limited funds, so they can't purchase glasses, for example, whereas they may have actually significant funds to do that. So that's an example. So improper information being relayed to the potentially incapable person, or they are incapable. And then that tied to my last point, spending habits being unnecessarily restricted. So generally, not all of these red flags may be in a case, but we have seen a common trend of these red flags. So these are important things to look out for in the event that you have concerns. And then if you have concerns, you can always reach out to John and I and our estate litigation department, and we'd be happy to assist.
So as we near the end of this presentation, and just before we jump into questions, just wanted to make it clear to everyone present tonight that at Siskinds we deal with all sorts of estate matters, from estate planning to estate administration, estate accounting, guardianship accounting, power of attorney accounting, guardianship applications, contested and uncontested, power of attorney disputes, and then will challenges and everything in between. So if you ever require assistance with any sort of estate matter, please do feel free to contact myself or Leanne, and we can direct you to the right person if it's not us. And I'm usually quite willing to, if I have time, to chat informally with a prospective client about an issue. So please feel free to reach out to us. So in terms of questions, so I'm looking at the Q&A and I see there's 7, and I think Leanne addressed one, and maybe there's a follow-up. So I'm just going to jump into the Q&A right now, and let's see what we have here. And Catherine, I don't know if you want to read the questions out, if that works better for you.
Sure. Yeah. Sonia and I can maybe take turns doing that. So I'll just start with the first one if you're comfortable with that.
Sure.
First question, generally speaking, what MOCA score range do you see in people who have been deemed to be incapable?
That's a good question. In fact, I just got an assessment, a retroactive capacity assessment done on one of my files with respect to a person's ability to make a will. I believe the score was 11 out of 30, but I don't have the exact information in front of me right now, but I do know that there's a spectrum of scores, and that you know, there's a bit of gray area if someone doesn't do so well on a MOCA, but they do well enough that, you know, there's still a possibility that they might have capacity. So when I stated earlier that sometimes I recommend that a client go to a family doctor or a geriatrician, they can have the Montreal Cognitive Assessment done, the MOCA test, or the MMSE test done. And if those tests are showing signs that there might be diminished cognitive functioning, it's usually at that point that I would recommend that the person proceed to a capacity assessment with someone who's specifically trained to assess capacity to make certain types of decisions under the Substitute Decisions Act.
Thanks so much, John. The next question says, do financial institutions have to accept the continuing power of attorney document? I've heard that banks often want their own documents to be signed instead or in addition.
So I have seen power of attorney documents executed in relation to certain accounts at not all banks. So generally speaking, so a continuing power of attorney for property, it should be accepted by the bank. They may require a notarized copy of that document, but they should accept it, and you should be able to manage those accounts on that person's behalf. Again, previously in our presentation, we did mention that if the continuing power of attorney requires that a capacity assessment be completed or that a doctor's note needs to be provided to support incapacity, the bank may say that that's required. But I have not come across a situation where banks rejected a continuing power of attorney for property. I have seen different types of power of attorney documents out there, but it's continuing power of attorney for property document should be accepted.
And just to add on to Leanne's answer, sometimes you'll have banks rejecting these homemade powers of attorney, the ones that you can print off online, because these power of attorney documents, they don't have the same safeguards in place that that power of attorney documents created in a lawyer's office have. So if I'm a lawyer preparing a power of attorney for someone, I make sure I'm satisfied that that person has capacity. Whereas if a person prints off a power of attorney document at home and has their neighbors sign the document, those documents are more susceptible to challenge. And so if there's issues that the bank are seeing, irregular activity, or a person's coming in with a different a person's coming in to access their bank account with a different person each time, large transactions, unexplained withdrawals or transfers, sometimes you'll have a bank saying, we don't want to be liable for this, so we're not going to accept this power of attorney, in which case sometimes the way around that is running off to a lawyer's office so the lawyer can make a notarial copy, a true copy of the power of attorney. So at least a lawyer's name is associated with the document, even though the lawyer did not, in fact, prepare the document.
So I'm hoping that the question about long-term care decisions and the capacity assessment that the care coordinators do as part of that process, I'm hoping that that has been answered to our attendees' satisfaction. If not, I invite this attendee to just maybe type in a follow-up question. The next question would therefore be then, what do you do if there is no will?
So I can answer that one, Leanne. So if there's no will, and this is a common misconception, if you die without a will, you're said to have died intestate. And everyone seems to think, or a lot of people seem to think, that all your property goes to the government. And that's just not the case. There's a piece of legislation in Ontario called the Succession Law Reform Act that specifically speaks to how a person's estate is distributed if they don't have a will. And so right now in Ontario, if a person dies without a will and they have a spouse, the first $350,000 of their estate goes to the spouse. And then if a person dies with a spouse and children, the first $350,000 goes to the spouse, and whatever's left over after the 350, that is divided equally between the spouse and the children. Now, if there's no spouse and there's children, the entire estate goes to the children equally. And if there's no children and no spouse, then we get into this hierarchy where the property's going to the parents. And if there's no parents, then it's going to the brothers and sisters of the deceased. And you can actually go pretty far down the line until you get to nieces and nephews. It all just depends on the deceased person and how what their family is made up of at the time they die.
So very rarely will it go to the crown. Because I get that, I think, John, we probably get that question a lot too. So if you don't have a will, it doesn't mean that the government just takes it. There's like a statutory list that John just went over as to who's next in line to inherit property. But we always recommend that a will definitely be prepared and executed with a lawyer, because there are extra complications that arise when there's no will.
And
Thank you.
so, and my answer to it was about distribution. So if someone dies without a will, therefore they didn't name an estate trustee, an executor. So what has to happen is quite often someone will have to take on the task of applying to court to become the estate trustee of an estate. And what you sometimes have, especially in families where there's a lot of conflict, is you will have brothers and sisters and siblings all vying to become the estate trustee, and those battles can become pretty expensive. So it's always a good idea, even if you don't think you have a large estate, to make a will. A lot of people think, oh, I don't have any property, I don't need a will. There's other decisions that need to be made with respect to a person's estate, even when the estate's not big. Funeral arrangements, obituary, contacting the government to get the CPP death benefit. All of those things become unduly complicated if there's no will and there's a fight about who should be the estate trustee.
Thank you. I think this question has also hopefully been answered to some degree, but might be a little different in that the person is still living and has no will, but are unable to speak or communicate. They can only gesture yeses and nos, but I'm assuming that we kind of already covered that. So if there's anything additional to that.
Yeah, I believe there is probably something just a little bit additional. So I think the question may be whether this person has capacity to execute a will. And just from the information that has been relayed, if she or he is nonverbal, it doesn't necessarily mean that they're incapable of making decisions. So if this person can gesture yes or no and fully understand and appreciate the consequences of making testamentary decisions, can appreciate their property, then they can meet with a lawyer. The lawyer can go through those questions and determine whether this person is capable or not to execute a will. But being nonverbal is not an indicator of incapacity.
Next question. If the power of attorney shuts out other supporting family members because of their own motivations, so the holder of the power of attorney, rather than the best interest of the incapable person, what is an appropriate course of action?
Okay, so this is what we deal with all the time, and so it's quite often you have to run off and retain a lawyer to actually deal with the situation, because if a power of attorney, an attorney acting under a power of attorney is restricting access, likely you have already tried to plead with them to stop doing what they're doing, and they are wielding the power of attorney around like a sword, saying, no, I'm in charge of the situation. I have this legal document that was prepared by a lawyer that says I'm in charge of these decisions. I don't care if you don't agree with my decision. So what happens is when I have a client come in who presents with this issue, usually I end up writing to the attorney who is acting improperly, reminding them that they have a duty to act in the best interests of the incapable person, and to foster a relationship with the supportive friends and family. Then I receive a letter back from the attorney's lawyer saying, well, you know, the incapable person just doesn't want to see your client, and they've never had a good relationship with your client. And so after a few letters back and forth, the client has to choose, are you going to escalate this by commencing a court proceeding? And these court proceedings, they can go any direction. You know, sometimes legal fees are enough of a deterrent for an attorney who's misbehaving to simply start behaving. But other times the attorney will dig his or her heels in, and we're dealing with a 1, 2, 3-year court battle about access to the parent. And the tough thing is, unlike when we're dealing with minors where there's legislation about access to children and visitation, there's no such legislation when it comes to incapable adults. And so I've seen these matters resolve quickly, but I've also seen these matters drag out for several years. And which direction this goes, it ultimately depends on you know, what findings a court is prepared to make about whether or not it's truly in the incapable person's interests that they're not in communication with a family member or a friend.
Thank you. This is just double checking. So siblings have a continuing power of attorney for property executed by their mother. And they just want to know, does this mean that the power of attorney is already in effect and nothing else needs to be done?
So it's in effect with continuing, but again, we have to look at the document in particular, and if there is a requirement that a doctor's letter is required, evidencing incapacity, or a capacity assessment is required to show incapacity, and then that would have to be done in order for the document to be enacted and used.
The attorneys also have to get their hand on the original. And so law firms lawyers at law firms who prepare powers of attorney documents, they usually have safeguards put in place so that if someone walks in and says, I'm you know, John Doe's attorney for property, and John Doe was in a car accident yesterday, or John Doe suffers from dementia, and you can no longer manage their affairs, that law firm isn't just handing out the power of attorney document, because once the attorney gets the original power of attorney document, they can go lodge it with the bank and they can start to wheel and deal with the incapable person's property. And so I have a continuing power of attorney right now. It's in the safe here at Siskinds. My attorney, my wife, she can't hold herself out as my attorney until she actually gets the original power of attorney document. So that's why it's really important to ensure that your power of attorney document, the original one, is stored somewhere safe, and preferably with a lawyer, so that it doesn't get into the attorney's hands before it should.
Okay, one last question. What has to happen for a spouse to get power of attorney over personal care if the caregiving spouse already has power of attorney over property? The affected spouse, I assume with the spouse with dementia, gave 100% permission because that person was scammed. If the affected spouse gives permission to the caregiving spouse, is a capacity assessment still required? Does that specify precisely enough?
Just reading it again. So it sounds like there's been a power of attorney for property executed, but not a power of attorney for personal care. if that's the case, if the grantor, who hasn't done the power of attorney for personal care, hasn't executed power of attorney for personal care and is incapable or has been determined to be incapable of granting that or executing that document, then there would be a situation of guardianship application, even if there was a permission given back when the person was capable. But that information would definitely be of assistance in a guardianship application. Person's wishes while they were capable. And then is a capacity assessment still required? So if there's still a, if it's undetermined whether the person is incapable of granting a power of attorney for personal care, then, and a lawyer has concerns, then yes, capacity assessment would still be required. John, you have any comments in case I didn't?
Yeah, so I mean, if we're talking about a spouse who wants to become the attorney for personal care for potentially their incapable spouse, we can also look back at the Healthcare Consent Act. You might not need a power of attorney document or guardianship if there's no fighting about personal care decisions that need to be made. There is that hierarchy in the Healthcare Consent Act that starts off right at the top. It's a guardian, then a power of attorney. If a guardian exists, then a power of attorney. If a power of attorney exists, then a spouse. Right, and so this in this instance, it might not be necessary for the spouse to obtain guardianship. However, I always recommend to clients to, if they have the capacity to make a power of attorney for personal care, make it. If there's money available for a guardianship order with respect to guardianship of person, spend the money, get the document, because it's far easier to deal with a person's healthcare decisions when someone says, well, what authority do you have? If you can present them with that piece of paper or that court order.
Okay, I think that might be the last question. Oh, one more. Oh, they just thanking us for our response. This was the earlier question about long-term care. And a thank you. So if there are no other questions, I will pause the recording and our attendees can make their way out of the Zoom webinar. So I'm going to pause the recording now.